I am an estate planning attorney. I have my own practice, my office in Plymouth. Each of you, if you haven't, maybe I'll put this over here in the corner. Before you sit down, there's a business card, and there is a one sheet here that has a couple of descriptions of what a will is and what a trust is. It is not all encompassing. If you've seen such descriptions in the past, you've likely seen many more descriptive items on what a will is and what a trust is. My take on that is that from what I've noticed, is an advertisement for why do you want to do a trust instead of a will. My sense there is a will is just fine for many of us. A will and a trust serve different purposes depending on your individual circumstances. So I've kept the description of a will and a trust at a minimum. At the bottom of that page, I would encourage you, if during our discussion, conversation this morning, you don't get something answered that you are questioning, wondering about, write it down. At the end, before we're done, I would like to take time to go through questions. And if we run out of time, I'd be happy to video it either afterwards or at another time. So, estate planning. I call estate planning for the living. Many of us think of it, well, we when I'm getting ready to die, I might do a will.
Thank you.
So,
I win that.
I give and bequeath my 2 camels, 2 horses and donkey to the Doris Duke Foundation for the Preservation of Endangered Wildlife. That's what we call an unusual will. In fact, Doris Duke also provides a trust for her dog. Her will happens to be long and involved, but her will can also be very short. Some of us say we're too busy to think about a will, or we don't want to think about it. Such thoughts bring to mind that unpleasantness of death. We're sure we don't need one. We don't have enough assets to make a will worthwhile. Or do we? You'd be surprised when you consider your assets to find you have more than you thought. Perhaps you own a home and a car, checking or savings account, life insurance, pension, IRA. You'll find that it adds up quickly. So, I want to thank you for taking the time to come this morning. And I also want to thank Mark Robinson and Maura Stedway of Minneapolis Financial Group, which if you've come before, you know them and have heard them speak as well. There was a little girl who grew up, got married, and had a first daughter, May. The mom had now great responsibility to take best care of her tiny baby. She was young, but she knew that the world holds few guarantees, and she wanted to make sure that little Meg was cared for by people with the same philosophy and values if something happened to mom. So that's how MJ Austin started. Not the law firm, but the seed of caring for ourselves and our loved ones. Today I'm going to focus on wills and trusts, what they are, the differences between them, and I'm also then going to touch on other important areas of estate planning. Family planning, like powers of attorney for finances and healthcare director, we're going to figure out where to stand here. How about, I'll try to stay put. So, I am going to follow my notes because I tend to ramble. So, this isn't going to work this far away, apparently. What is a will? It creates a plan to distribute your property and to leave your care. Why make a will? A will has the opportunity to serve your assets at your death. Important as it is, it has no authority until you die. For many of us, again, death is just something we'd rather not talk about. The problem with that is we are all going to die sometime, and not to have made arrangements for our loved ones. The way we want is to live with our hearts and our heads in the proverbial sand. So if you don't have a will, your estate passes according to state law, which may not be what you want. There's no executor, called a personal representative, named to handle your estate estate and no will, no one appointed to look after any minor children we might have. An executor in court then will have to name someone, pay off proper debts, sell a home, take care of final taxes, and distribute assets to beneficiaries. Court will do that. And if you have young children, a guardian will be appointed by the court in the event that you and your spouse were killed in an accident. So without a will, someone will have to petition the court to appoint a guardian. There's no guarantee that the court will know just the right person to name, and this can cause family conflict. When my first daughter was born, I knew who I didn't want to raise her when we left her with family for the first time. So I made sure we went to my father's attorney. We had a will drawn up. I knew, even at that young age, that things don't always happen to other people. It was important to me to have somebody in place. For you are creating a pot full of trouble for your family, not the least of which could be family infighting. There was a father's son. Father had a business. Oldest, the only son, who was the oldest, had 3 younger sisters, and the son worked in the business with the father. It was understood in the family that the son would inherit the business and the daughters would be taken care of in other ways. At the father's death, there was no will in place. The daughters
I'll
and
give
3
him a meeting.
sisters
I'll
had
call you
never
back
worked
when
in
I'm
the
done, okay?
business. But they came forward to get their 1/4 share without bankrupted the son. He did keep it going, but by the fear of his skin. So, and Jane sat by the bed of her dying mother with her 2 sisters, and one of them said, "Well, Mom, have you got your affairs in order?" And the mom, kind of jokingly, I hope, said, "Oh no, I'm going to let you girls fight it out." And Jane said to me later, "We didn't think we would." But we did. We did. So bear in mind that a will provides a legal statement of your wishes following your death. Too important to just leave to chance. So, do I really need a will? I'm married and we own our assets jointly. Won't that be enough? Not always. That's a common misperception. Spouses cannot always take care of every situation. It doesn't always work that way. This is a story I'm going to tell later. So, don't assume that because you hold all your assets jointly with your spouse that you don't need a will. What happens if both you and your spouse die in an accident? I had that, was in a business meeting earlier this morning where a financial planner got up and talked about the fact that he had somebody, gal died and she had beneficiary designation for a partner. They died in the same accident. There was no subsequent beneficiary. Look at your beneficiaries designations. There was no successor beneficiary named, and they both died in the same accident. It happened to will. The assets can flow from husband to wife and from wife to husband, but not further. So, I'm a single parent. What do I need to do? Upon divorce, a current will that names a former spouse is no longer in effect. A new will needs to be drafted whenever there is a life event change. Former spouse is considered to have predeceased you, and they're no longer included in the will. There is a need to update your estate plan so that your children can be taken care of. So, I have a will. Do I need to look it over? It's important to do that. We say every 3 to 5 years, look over your current estate plan, see if it still fits you, or if there is a significant life change. I already mentioned divorce. What was important when that will was drafted, I've had people come to me and bring a 30-year-old will. The named executor or personal representative may not even be available, or they have changed their minds, so it's time to look at that. I'm married for the 2nd time. What's important now? In second marriages, it's crucial to everyone in the family that wills are drafted to make sure that everybody is considered. Second marriage. There is new spouses love each other. They may have his kids, their kids. After first death, are there arrangements in place so the children of the spouse who just died are taken care of? Pretty important. I see more and more couples being married for the second time, taking the opportunity to set up prenuptial agreements. Important. Those are agreements that can be put into place before entering into marriage so that legal matters are taken care of. Love is great, but when the bloom is off, it's important to have taken care of important arrangements ahead of time. I've heard this over and over again. Why can't I do my own? Why can't I do a homemade will? The state of Minnesota does not recognize what we call a holographic will. That's a handwritten one. Some people do not appreciate the complexities that can be in even a simple will. And we'll go online and we hear a lot of advertising. I would not recommend it because it's an individual, it's not a fill in the blanks. It's an individually drafted document. One word can make a difference. I'm a real budgeter. I like to save pennies. But the do-it-yourself in this area may not have the results that you want. We wouldn't want an eye doctor to handle our heart surgery. It's easy to get a budget document that doesn't do what you want. I had a friend a few years ago who called and said, my wife and I have got our will, we'd like you to look it over, which I offered to do, by the way, in an existing will without charge. I thought that's what they were coming for. Well, they had talked with one of these entities that are you pay so much a month and you have 24/7 legal advice. So they came in, we looked at the document, and it didn't distribute the way they wanted to. They didn't know that. They had never met with an attorney. They talked on the phone. I'm not sure if it was with the attorney or the paralegal. The will was drafted and sent to them with cover letter instructions for signing. The cover letter for instructions was not even correct. It was old law. So we sat and we fixed that, documented off. They went and probably had it executed. The point is, this is not a do-it-yourself. Like most estate planning documents, it is really tailor-made. Can I change my will? Yep, you can change it at any time. It isn't, once you get it done, it doesn't mean that it's there forever. You can change it. When you change a will, the name for that is codicil. If you have a trust and you change that, it's called an amendment. You can change one little part, and the rest of the document stays in place. Moving on to trusts. So, I have a pen here. I own this pen. And I'm going to be called the trustor. That's the one who sets up the trust. It's my pen. I'm going to have you be the trustee. She is now the one who takes care of that pen for you, who are the beneficiary. I'm the trustor. You are the trustee. You are the beneficiary. That's what a trust is. Property owned by one person. Somebody else is named to take care of it for them for the benefit of a third party. So how's that different from a will? Well, a will sits on the sidelines, as I've already mentioned, while we're alive, waiting without authority until death. Then if the will is filed in court, the executor administers what the will says, distributes to beneficiaries, and the will is generally done. Trust, on the other hand, has additional properties. It can take the place of a will. It is in effect when signed, has instructions for what to do if the trustor is disabled, either temporarily or permanently. It can name a trustee to act as custodian of assets for minor children until the parents want them to inherit. If I have 3 kids, 8, 10, and 15, and if something happened to me, let's say 5 years from now, some of them would be over 18, they would be considered adults, for instance. They might, if there was a will in place, they'd get their assets at that place. Now, I might not want them to have the whole share at an early age. If you think about how mature you might have been at 21, 23, maybe not. A trustee can hold those assets, use the assets that would be going to that beneficiary for education, for taking care of their health, their food, their living expenses, etc., but not the whole thing. They can name a trustee to act as custodian meant for minor children. It does everything a will does and more. So when should I set up a trust? When you have a situation like that. If you own a cabin in Wisconsin, or if you own real property outside the state of Minnesota. If you have a will in place, you die and you own a cabin in Wisconsin, we'll just say. There will be a probate opened in Minnesota and a probate opened in Wisconsin. Our estate planning law is state mandated. Minnesota has no jurisdiction in Wisconsin for real property purposes, unless you have a trust. A trust can take care of all of that. A trust is a private instrument. There is no court involvement, as opposed to a will, which is cases opened in the county where you live. The will then is a public document. I already talked about property in another state. Now, another reason for having a trust is my family has a cabin. We just really enjoy it. My grandfather started it. We've been enjoying it. Our children love it. We want to be able to pass it on. So many people have enjoyed that lake, and they want their family to continue to enjoy it for the next generations. So a cabin trust can be drafted to outline how that will happen. How do we divvy up costs for capital improvements, for fixing the roof, for paying the taxes? How do we arrange for who gets to use it when? Can you imagine down the generations as it could be owned by more and more people? Cabin trust. Okay. Second marriage, we've kind of talked about. That is a good time to at least look at having a trust. Story. Ted's mom died. His father had married a woman with 2 children of her own. Everyone got along famously, and Ted was given to understand that at his father's and stepmother's deaths, their estate would be split evenly, Ted and her 2 children. Well, I said mom died, actually that's what I was looking at. Dad died before stepmom. At stepmom's death, several years after that, much to Ted's surprise, she had left the whole remaining estate to guess who? Her 2 children only. Ted was completely cut off. Family heirlooms, which meant a lot to Ted, now belonged lock, stock, and barrel to stepmom's children. Dad had made the unfortunate assumption that his second wife would look after Ted in her will. Oops. Special needs trusts. The trusts that are mandated by the federal government, administered by the state of Minnesota. There are 2 kinds, special needs trust and supplemental needs trust. These are for people with disabilities. I have a special interest in this. I have a daughter who's a quadriplegic due to a skiing accident as a senior in high school. She's made a wonderful life for herself. If I die tomorrow, there might be a couple cents left for her. She does get government benefits because she has long-term, lifetime medical needs. She's in a wheelchair. She has medical needs ongoing, very expensive. If I would pass anything to her directly, she would no longer be eligible for government benefits until that was all spent down to pretty much nothing. On the other hand, a supplemental needs trust can be put into place so that at my death, anything I would want to go to my Jenny will go to a supplemental needs trust. It's important for people with disabilities. It allows her to have a richer life than she might have without it. We talked about wills and trusts. So write down your questions if we didn't answer everything that you had in mind. Healthcare directive. That's what it's called in Minnesota. We know about the living will and the power of attorney for healthcare. It's called a healthcare directive, and there are 3 parts to it. One part is, it says what you do or do not want to have happen if you are in a terminal condition, if you're not going to get better, you're going to die soon. Don't keep me alive forever on a machine. We know that. We've heard much about that. So that's one part. Another part is you can name people to act for you if you can't. Say that again. If you can't. That's important. And as long as you are competent to say what you want, you are in charge. Don't forget that. But if you can't, you can name your spouse, you can name your family, you can name somebody you trust who you think might be able to do that. With the HIPAA privacy laws that we have in place, anybody that you would want to be able to talk to the doctor to get medical information really ought to be on the healthcare directive, or they might not get access pretty much to anything. I have a friend whose mother was in hospital in Arizona, so she called to see how her mom was doing, and they wouldn't even talk to her because she did not have her name on the healthcare directive.
What if I have a college kid? I can call, right? Because they're my kid.
He's over 18. You bet. Yeah. It used to be just kind of nice information for your family. That's not the case anymore. I always say, the second thing they ask you after they ask you if you go to the hospital, do you have medical insurance? They want to know if you have a healthcare directive. I do have one that I use. You do not need an attorney for a healthcare directive. There are lots of them out there. I think Mark has suggested the 5 wishes. You may have heard of that. What must happen is the healthcare directive have 3 things. What I do or do not want, and I can name somebody who do not have to, and then the 3rd part is signing it. It must be construed for state law. That's all. There is not a specific document for that. So we say, well, gee, can't my spouse take care of health matters for me? No, we're married. Doesn't that count? It's not automatic. I've heard, I have a friend whose husband had an accident and he was in the emergency care. She really had to prove who she was to even get through the door. So just so you know, it doesn't always happen that way. The other part, those trusts, healthcare directives are while I'm still alive. By the way, at my death, healthcare directive goes away, no longer in effect. The other thing that is applicable while I'm alive is the power of attorney for finances. I call this the no-brainer. Why do I need it? Well, it allows you to name somebody to manage your finances. In case of temporary or permanent disability, it's important to have. I have a story about a client. I met the wife. Never met the husband. He's about 50, I think. He had a terrible car accident. He is in a permanent vegetative state. He will spend the rest of his life in a nursing home. The wife needed to sell the home that they had and move to a different one. She had a buyer for the home. She had another home picked out. All they needed was to have the deed be able to be signed. Well, there was no financial power of attorney in place. In that case, spouses can't sign for each other. They had bought the home, they had both signed the deed. Several $1,000s later with filing fees, court hearings, legal fees, we petitioned for our conservatorship. Guess who was named to sign? Who was named as the conservator to sign? The wife. So with the power of attorney for finances in place, that wife could have been on his power of attorney. There would never have been no need for the delay and the costs involved. That is a document. We use one that the legislature actually did. They made the document itself. And just as a point of interest, let's see if I got it. You've heard of this elder abuse where, for instance, a son gets a power of attorney for his mom, cleans out her assets, and whoopsie daisy. So the legislature a year ago made a couple of changes to the document. Now it's important to say, and specifically say, is there a time when it would be okay for the people or the persons, you can name 3, that I'm giving the authority to take care of my finances? Would there be a time when it would be okay for them to, for instance, cash a check from my checking account to them personally? Not to take care of my finances for me, but them personally. And we can say, it's okay for the first one, not okay for the second one or the third one. We can delineate. And that is an attempt, at least, to get around this. I've named somebody and whoopsie, off they went. Person that sons, I don't know if that would have helped that. I do have another story about a guy came to me and he said, my aunt just died. He said, I used to watch out for her. I'm the only living relative. She lived in St. Paul. He used to live in the Twin Cities. He and his wife moved out to a small town in western Minnesota, so they weren't available. In the meantime, this gal living in St. Paul, elderly, had her own home and lived next door to some really nice two gentlemen. So they kind of, she took care of their doggie and they used her garage. Nice, friendly atmosphere. At her death, they had her financial power of attorney. They owned her home and all of her investments. So we had to take them to court. Be careful with your financial power of attorney. Had a call yesterday. Large firm downtown had an issue they needed help with. The scenario that they told me was, Mom has property in Florida up for sale. They had a buyer. She was concerned because she had not seen any of the closing documents. Why not? This was yesterday, the phone call came in, closing is today. I said, why haven't they given her the documents to look at? Well, her son and daughter have her power of attorney for finances. I said, well, is she competent? Oh yeah, she seems to be really competent. I said, well, first thing she ought to do is reschedule that closing. And the other thing was, after the closing, she wants to terminate the power of attorney for finances. I said, well, let's see now. If I were talking with her, I said, why don't we do that right now and make that closing be later and you take care of your own closing. Be careful about letting, the attorney said, well, got kind of a bossy daughter. Really? Be careful with that. I have a power of attorney for finances set up for one of my daughters is me. I keep control of those documents. They can know where they are. I might change my mind. But at any rate, they're my documents until they're needed. That power of attorney for finances is in effect when signed. You heard me say the healthcare directive, only somebody else can make decisions for you. If you can't, the power of attorney for finances is ready to go. You can choose. Somewhere along the line, that mother must have said it was okay for bossy daughter and son to take care of things. Now she's not so sure. So she can take charge again. Be careful with your stuff. So after death, probate. We hear awful stories about probate. Is this to be avoided at all costs? I get in the mail, which you may from time to time, come to this seminar and hear about how terrible anything but a trust is. Again, as I mentioned at the very beginning, my differences between wills and trusts is short, it is brief. I am not of the opinion that everybody needs a trust. Attorneys earn more money setting up a trust. And a trust is wonderful and it fits many circumstances. But they're both important. Probate. A will is taken to court. That is a misconception. We think, well, if I have a will, then I don't have probate. That's what it's for. So, it really gets a bad rap. We'll talk about avoiding in a minute. I had a gal, 90-some years old. She died and she had a will. She had quite a few assets. And her probate took several years. Why? Because the person she had taking care of her finances hadn't filed taxes for about 10 years. I mean, she was worth quite a bit of money, so the IRS had quite a bit to say. My point is, probate is a process whereby a court helps by looking at the will to see if it was properly executed and the personal representative is named. If there is no will, there's still a probate. Only there isn't a will to clarify what you wanted. If you are organized, if you know where your stuff is and you don't, the bad that probate gets is generally because the person just wasn't organized and the family couldn't find their stuff. When you open a probate, the court looks over the will, or in the case of no will, names somebody to act as the personal representative or the executor, same thing. And then there is a 4-month waiting period for any creditors to come out with brochures, even if there are no creditors. That's by state law. But I don't see that as a terrible reason not to have it. I think it gets a bad rap. So, is a probate always needed? I have a client in the state now where the mother died. She's the mother of a friend of mine. A year or two ago, the friend asked me to help her with healthcare directive and financial policy, which I was happy to do, and then suggested that she come back in and we talk about the rest of her estate. And she said, okay. Her family suggested that she do that and recommended that she do that. She didn't. So she just recently died. And as it turns out, there will be a probate needed. She had only a house. We could have done a transfer on death deed. It's kind of like the checking account. You could put a payable on death, which means that's one way to avoid probate. If you have a checking or savings account, you can put POD on it and who it goes to at your death. That's a way of passing assets. If you have funds, investments, transfer on death does the same thing. And you can do that with your home as well. In her case, the expense and the time involved in a probate could have been avoided if she had just talked. I didn't know what her financial situation was. I only helped her with those other 2 documents. So maybe it's a good thing to talk to somebody. Somebody did this PowerPoint for me, and they put, probate is a good thing. I don't know if I'd go that far, but I think it's just fine in many cases. Be organized. There is a talk about a wish list there. That's another name for a family letter. I've had many clients who have other things to talk about with their family. Maybe memories, where they want to be buried. We don't usually put funeral arrangements in a will or a trust because that document is often not available when funeral arrangements need to be made. So it can be very personal. I've had others talk about their values, their philosophy. You can put most anything in it. It's a family letter. It's not legally binding, it's just a visit with your family. It can include heartfelt wishes to the guardian of the young children, if that's necessary. It could be a video or an audio tape. So, I would like to take a minute to just visit briefly about the fact that estate planning, financial planning, your insurances, on and on and on, all of these financial things that I've had people say to me, I don't like to do that, I don't like to do that. Well, it's time to do that. Not only estate planning, which is what I'm here for today, but financial planning. They go hand in hand. A Mark Robinson, a Morris Stifley, Minneapolis Financial Group. I happened to look on their website. This is what they call our commitment. Local residents and businesses rely on us to help secure their financial futures, but our commitment doesn't end there. We believe that in order to build long-lasting relationships with our clients, we also have to serve the local communities in which they live and work. Careful life care planning can make a difference in the quality of life for your loved ones and other family members, including yourself. The stress and fear of not planning often paralyzes any planning at all. Knowing this, we, Minneapolis Financial Group, Mark and Stephanie, will help you through that intricate process. Our working environment is characterized by teamwork, trust, and cooperation. We work together to serve you. We honor our commitments and hold ourselves and each other accountable. We support the best in each other and know we can be the best financial services organization in the area. We are determined to succeed. As a closing, I want to say that it is not unusual for my clients to thank me when they complete their estate plan. There is real peace of mind doing what you can to make clear what your wishes are. One of my professional goals is to keep that planning process going. One of my clients, and I thought this was interesting, they came in to review their documents and to sign their documents. And the gal said to me, Margie, this is the third time we've gone through this. The other 2 times we just never completed it. Oh. I don't know if they paid those attorneys or not, I hope not. But anyway, we keep that process going. Take time to have that conversation. Talk to an attorney. The process doesn't have to be difficult or uneasy. I believe that estate planning is truly for the living. It does bring peace of mind to our lives, and we've done what we can to help our loved ones. Have time for questions?
I was going to add the third thing to that, which is
Yes.
it doesn't need to be expensive.
True.
One of the reasons why we have partnered with Marjorie is that she doesn't have a single menu price. If it's a will, it's this price. If it's a trust, it's this price.
Because it's individual.
It's individualized. I had a number of clients that had gone to one of these free meals on estate planning, and I kind of characterize those as trust mills.
That's what I was alluding to.
Everybody gets on the trust mill conveyor belt, and when you get done, you get a $5,000 bill and a document about this thick.
With a lot of paper, but the same documents.
So I have a personal story.
Okay. I'll keep my mouth shut.
You're gonna like this one. My father-in-law, after years of bantering with him, I should be his financial advisor, finally started letting loose with some of these documents. And he gave me his estate plan, and I read through his trust. And I mean, I've read hundreds of these trusts, and at the end of it, I had dog-eared question marks, circles, yellow highlights. And I said, Florian, I said, I don't understand any of this. Can I give it to Marjorie, a professional associate, just have her look at it? So she looks at it, she goes, I think I better talk to you and Florian in a conference call. And I love this quote. She goes, well, Florian, you know I write these things for a living and I don't understand a damn thing this document says. The shocking reality is that he married up with this estate planning attorney, and I was shocked to find out that year to date, when we finally got wrestled it away from him, he paid this attorney $20,000.
Whoa.
And what this attorney was telling this highly intelligent professor from the University of Minnesota was, there's some changes this year, we better go back in and we better do a codicil on this or amendment on that. And he was charging like $500, $1,000 per amendment. And fortunately, because of our relationships, he says, I'm gonna knock this thing down and I'm gonna redo this thing for pennies on the dollar compared to what she paid. And the point of this story is this. This Lunch and Learn is the third part of a sequence, and we've been building up to this point right now, which is to make it pretty apparent. In our minds, it's totally irresponsible if you go to death, like my mom's going to do, clutching the last dollar in her hand. We thought maybe 10 years ago it was a good idea not to have an estate plan in place. Is that it's irresponsible to die without something, whether it's a will or a trust. It's just flat out irresponsible. Now remember last month we were talking about how do you as trustors and executors, how do you get your mom and dad off of that last dripping dollar to do something? And it oftentimes starts with us showing them what we're doing. And they're like, oh, well, maybe your father and I should do something. Okay? The point of these trusts is that when you pass the document to the trustee and say, upon my death, everything you need to know is I want fully executed in there, they should be able to pick that document up and during commercials of Wheel of Fortune, read it, understand it, and be able to execute it. If you got to call up the attorney and go, I'm on page 6, paragraph 2, line 5, what does that mean? You ought to be hearing cha-ching, and it's not the commercial or Wheel of Fortune, that's the attorney saying, you need my help to decipher page 5, paragraph 2, line 3, and on it goes. Okay? So today, we'd like to, if you have a couple of questions, the first initial consultation, you know, if you want to talk to Marjorie about questions on follow-up after today, her telephone number is there, give her a call. It's about giving you the information, educating you about the choices today between a will, trust, healthcare directive, and the benefits of powers of attorney. I'm sure we all have personal stories about things that have gone terribly wrong because the documents weren't in place, not easily understood, or in some cases out of date. So does anybody have any immediate questions they want to ask Marjorie before we?
How do you go through probate when someone dies? Do you have to file?
Yes. Generally, you file a petition to open a probate. The registrar goes through all of the documentation with the attorney and determines if everything is in place. And then a case is opened. You get a number, and the personal representative receives a letter. Letters of testamentary, that gives that personal representative the legal authority to take care of things.
Kathy, when someone dies, the death certificate's issued and then the county is made aware and now the county's hunting for that person and their assets.
Does anybody here have a family cabin trust in the estate plan of mom and dad, anything like that? Okay.
It's getting to be more and more common.
It is. And keep in mind that we can't give you tax advice, but there is substantial tax benefits when there's assets, like a cabin trust, when mom and dad passes away. Because if it's held in mom and dad's name, and you try and change the title to Mark, Maura, and Marjorie, you're going to create a taxable event. As opposed to that cabin is held in the Mark Moore and Marjorie Cabin Trust, and there's X number of beneficiaries listed, there's no exchange. Even when someone dies, the title doesn't change. That title goes on in perpetuity until such time that the trust decides to sell that cabin. So a personal example, then my mother-in-law passed away, bought a cabin back in 1969 up on a beautiful lake. What do you think the cost of that was?
13,000.
$5,000. A lot of money. Well, a lot of money back then, because $5,000 was worth $5,000 worth of gold, probably. Upon her death, that cabin was worth $230,000. We turn that cabin over now, what's the cost basis, or what's the taxable gain? A lot of chingadero. It was in a cabin trust. The day she died, nothing changed. But everybody that was a beneficiary now has a stepped-up basis. You may understand what that means, a stepped-up basis. It's not $5,000 anymore, it's $230,000. Now if the trust decides to sell that cabin 10 years from now and it's worth $300,000, what's my taxable odds of it? $50,000. What would you rather pay on taxes? So there's a lot more that goes into these trusts, and we work in concert with a CPA attorney. He's the one that does our March tax preparation and planning. So, you know, if there's questions or there's circumstances that are individual to your own needs, we've got the people that are there available to answer your questions, okay? All right, so the document in front of you, we got to have that. Don't forget to initial, because some of you did show up as you were passing through your lunch on our video.
You need your first and last name. If you want us to follow up with you, say yes. If you don't, say no, because if you don't say anything, I still have to check with you to see if you want me to follow up. And I am a mother, but I'm not your mother, so please clean up your lunch. There's 2 trash bins by the door.
Thank you all very much for coming.
Anybody need a card or sheet? Did you not get one, anybody? Yes, you did.